Got it?
And there we are.
Fantastic. There we go. Great. Well, welcome everyone. I'm always excited to bring educational information to employers that are dealing with unemployment claims in DC. I think there's a lot of misconceptions that people have about how unemployment actually works. And so the purpose of this presentation is to give more guidance on what constitutes misconduct for purposes of disqualifying an employee for unemployment benefits in DC. So again, as Don stated, I am the very proud employer advocacy program director at the DC Chamber. Essentially, DC Chamber has a contract with the DC government, with DOES, to provide free legal representation to employers that are facing an unemployment appeal with the Office of Administrative Hearings. So people get that confused. There are two government agencies that deal with unemployment in DC. The first is DOES, which is where the employee would go to file a claim, and then DOES would reach out to the employer to get information so they can make a determination. And then DOES says, yes, the employee gets unemployment, or no, they don't. And then either side has the opportunity to appeal to the agency that oversees all of DC's agencies. So it's a judicial agency that oversees all DC government agencies. And so we have an appeal, a hearing of DOES's determination. Okay, so I am an attorney here in DC. I'm a proud DC homeowner and solo firm owner. I graduated from Howard University School of Law, cum laude, and I'm also a former federal law clerk. So I have some experience in seeing what does and does not work when people go to court. I do like for these to be interactive, so please, please, please feel free to ask questions as we go along. I may even pick on members of the audience to just keep this engaging for us all. All right, so this is what we're going to cover today. We're going to first look at some common misconceptions about what is disqualifying behavior that an employee must engage in order to be disqualified from unemployment. We're also going to take a look at the actual legislation of DC that governs unemployment misconduct. So that way we're all clear on what the definition is. It's not just what the employer thinks. We really have to fit what has happened in with the regulation. And then we're going to go over a few case studies of the common types of disqualifying behavior that I've seen come forward before the Office of Administrative Hearings. And lastly, we're going to just talk about a few tips on preparing for that unemployment claim as well as the appeals process. All right. So, true or false, and I'll get you guys to just drop me a chat, please, about some of the common misconceptions about unemployment benefits. Oops, I'm sorry. I clicked the wrong thing there. All right. Number one, subpar or poor job performance bars unemployment benefits. What say you guys? True or false? Just drop your answer in the box, please, in chat. Come on, fellow chamber people, help me out. No one? Miss Hall, I'm going to call on you. What do you say? No takers. All right. The answer to that is false. There you go. Thank you guys. Yes. So a lot of times people, employers will call me and they say, look, this person really just, they didn't do a good job. And so, I had every reason to terminate them and they should not get unemployment and essentially make my unemployment rate increase for everyone else. Well, the response to that is that DC unemployment, of course, also nationally, is that it is actually a social safety net. Okay, so this is not as personal, I think, as employers often think it is for someone to receive unemployment. The whole purpose of unemployment is to ensure that we don't have um, people that were unemployed, kind of unexpectedly and to no fault of their own, and therefore either increasing the likelihood that they engage in crime or now they start weighing heavily on other government entitlement programs. Okay, the whole purpose is you're an employer, you've got to make more intentional decisions about terminating individuals. And so, just because somebody was not good at their job does not mean that they're not going to get unemployment. What are some things that an employer can kind of do about that? I would say employers should definitely seek references from the employee's past employers. That kind of give you a clue of whether or not this person just kind of has a history of not being so great at jobs, and then getting being let go. So that gives you an indication of whether or not maybe you should hire. There are a lot of other like qualifying questionnaires that employers are now starting to use to see if this person really is a good match to do the job. So I remember one example that I've had an employer said, look, the person just wasn't a very good writer. So one of the things you could do is like seek a writing sample if that is something that a job task that you really need that person to do. Um, and then also just generally just get their resume so you can try to, and then also do some internet research to see like if they're on LinkedIn, and you'll see if they've had long gaps of unemployment. So that might can give you some indication there too that maybe this person is a little bit more of a trouble employee than maybe they're worth. Okay. Number two, come on and thank you for responding, and please provide answers in the chat. Termination for cause. A lot of persons say, I terminate this person for a reason, good reason. That should bar them from unemployment. Does that bar them from unemployment automatically? True or false? Right. Excellent. The answer is false. So, one of the things that we often see at the very end of an unemployment appeals opinion from the court essentially says, the court is not taking issue with you having a right to terminate that person. You might have had good reason, but it does not meet, and you did not prove one of the statutory types of behavior that would disqualify the person from unemployment. So, a lot of employers get really upset with this because they say, look, I really had good reason to do it. But you have to understand, unemployment is not personal. And so, if you really are going to take an issue with an employee getting unemployment benefits, you really do need to look at the statute and see if you have that qualifying behavior and essentially build kind of the case related to unemployment before you make that decision to terminate. Otherwise, you might find yourself thinking you've had good reason to terminate the person and then still get hit with the unemployment bill. Lastly, it's an effective strategy to wait until the unemployment appeal to build a case, to build your case. I'm gonna wait for a few responses. True or false? Right, absolutely, of course. And the answer should have been obvious here because this is misconceptions. Right. Most people don't know that once you get a determination letter from DOES, you only have 2 weeks to appeal it to the Office of Administrative Hearings. Okay, so you have about 15 days, so 2 weeks roughly. Um, once you file the appeal request, then once the court issues the scheduling order, you've only got 2 weeks to prepare. So when you're coming to me to help represent you, I've got literally less than 2 weeks to help you get ready because I know nothing about the case. And then you also have to get all of your documents together to send to the court 3 business days before the hearing date. So we've got a very crunch window to prepare. So I say preparation for, winning an unemployment claim slash hearing starts with before you terminate the person. So we're going to go through some of that today. All right. So misconduct for purposes of disqualifying someone from unemployment in DC is defined by statute. The statute is 7 DCMR section 3112. And there are two types of misconduct. There's gross misconduct and there's other than gross misconduct. I've put the full definition of both here, but suffice it to say, both types of misconduct require that the employee actually have done something intentionally, so not just excusable neglect, something they have to have acted intentionally, and they have to have known that whatever behavior they engaged in could result in their discharge. Okay, so that's regardless of what type. Gross misconduct is an act that is deliberately or willfully violated an employer's rules. It deliberately or willfully threatens or violates the employer's interests, and otherwise shows a disregard for the employee's obligation to the employer, or just generally is so egregious that it's disregarding any reasonable standard of behavior for which employers have a right to expect of its employees. Gross misconduct will completely bar the person from receiving unemployment benefits at all. So they get nothing, and then there's no hit to the employer's um, account, which could then therefore protect it from being an increase in the rate that the employer has to pay for all of its other employers. Other than gross actually does not completely bar the person from receiving unemployment. What it does instead is limits the number of weeks. So it basically decreases the amount of money that comes out of the employer's unemployment pot that they've paid in over the years. It limits the number of weeks that the employee can receive. So therefore, hopefully it doesn't um, by reducing the amount, hopefully the employer still is in a position where their unemployment rate doesn't increase. But other than gross misconduct, essentially it just is an act or omission by an employee which constitutes a breach of the employee's duties or obligations to the employer, breach of the employment agreement, or which adversely affects a material employer interest. However, the severity, degree, or their other mitigating circumstances don't basically rise to the level of gross misconduct. So it's essentially a little less severe conduct than gross misconduct. So I've given you some. There's a statutory list of the types of misconduct that the court is looking to have the employer improve. It's supposed to not be exhaustive, but frankly, I really don't see the court um, agreeing with the employer for anything other than the statutory reasons. And here are some of the primary ones. For gross, arson or intentional destruction of the employee's property or that of its clients. So if we have a case where the employer can prove that the employer destroyed fowls, or they actually intentionally set fire to a building. That's a very rare and extreme case, but it does happen. The next one is intoxication or other substance abuse on the job. And then hopefully you can see this here, but essentially theft or attempted theft, either of the employer, basically the employees stealing from the employee, or of the stealing from the employee's clients. And then a type of behavior that kind of falls on the line between gross and other than gross is absence or tardiness. It'll be considered gross misconduct if the number, right, is so frequent. Like, so you've got somebody that had 10 absences and tardiness within a month versus maybe someone that has three or four that might go into the other than gross category. Another example would be essentially an employee that is doing something other than doing something personal at work. So instances where maybe the employee is shopping um, online or using a cell phone. It does help to have that in your employee manual to make sure. An employee that is using profane language would also be considered gross. I'm sorry, other than gross misconduct. And then you might have a situation where the employee just isn't isn't really doing any work, right? That's what I would say, the unmotivated employee. All right, let's go over some case studies. So one of the biggest reasons to have an employee not receive unemployment benefits is if you can prove that they had absences, unexcused absences, or tardiness. Okay, so key thing is that an employer always has the burden of proving these instances. So it's not sufficient to just kind of wing that. You really need to document what you have. I'm sorry, you need to document this person's violation of your absentee or your timeliness policy. So one thing, there are a couple things you for sure need to have to be successful on this type of a claim. One, you need to have known and consistently applied rules. So most employers know that they need to have an employee handbook. you need to have a provision in it that explains what constitutes excused and unexcused absences and tardiness. So you need to make that clear. Sometimes you might even need to make clear, like, okay, after X number of minutes of being late, it will be considered an unexcused, tardiness. Um, just be very clear of what is going to be considered an unexcused absence or an unexcused tardiness in your manual. And then you also want to make sure that you have documentation to show that the employee received that manual and they acknowledge the rules. Okay, that's the way a lot of times employers can kind of lose their case because they can't prove that the employee knew that if they were more than 15 minutes late, that could be grounds for termination. Okay. So you got to make sure you have that documentation. And a lot of us are using technology and software more. So you want to take some time to just make sure that you can easily turn whatever it is on that software into a hard copy document or PDF. What we have to do for unemployment is submit PDFs to the court. So take some time to look at your systems and see, can you print that out? Can you download the manual? Can you download the acknowledgement form and print it out? And every time you update that handbook, you've got to have the employees sign that they received the um, updated manual. Okay. Secondly, you got to apply these rules consistently. So you can't have a situation where, and I know this can be tough, but you can't start excusing some people's absences or tardiness without doing the same for others. You can't have this imbalance. So you got to have clear rules for when you're going to excuse it and when you aren't. And you need to document. So if you have an employee, for instance, that has a lot of absences, but they bring you a medical note, then maybe you do excuse that, but you want to be very clear in your rules that if someone can prove absences related to something medical, then those would be excused. But then you also want to make sure you have medical notes from those that you're excusing, and then you could be able to prove that, hey, these other people were just absent and they didn't provide any proof for justifying their absence. Okay. Second point then is we've got to actually prove the absenteeism, tardiness, and just generally a timing. So preparing for a unemployment claim related to this, you want to make sure that you have a couple of things ready to go as PDFs. You want to have the timesheets, and those timesheets need to be accurate. One of the things that I've seen employers try to do is they're trying to help person, so they'll do things like complete their timesheet for them so the person is in case the person is not checking in or out. Don't do that. They didn't check in or out. Let that be clear that that's what the person did. If you're going to try to capture their hours, you need to just have another field that shows this person did not clock in or out and they arrived at this time and they left at this time. You also want to have a schedule. So you want to be able to prove that this person received the schedule. They knew they were supposed to, report to work on these days. And then here's the clock in and clock out system showing that they did not actually come on their scheduled time. And then don't do any cleanup. I mean, again, I know that we're trying to be good employers and help people, but cleanup sometimes hurts us. If you're going to do any cleanup, you want to make sure that you're documenting how you clean that up. Okay. The next thing that you have to do to get someone disqualified for absences or tardiness is you've got to show that you gave them a chance and you gave them warning. So ideally, you do a corrective action plan. So first, so you might say, hey, if you're absent or tardy, twice within the same week, you're basically going to get a verbal, conversation. So we can just see, we do want to be good employers and know maybe somebody really does have something medically going on. Maybe there's some family stuff going on. And then if that's the case, there are other DC related employee benefits that maybe the employee can tap into. But you want to show that you work with the person, you had that conversation. So first couple of absences, tardiness, you want to give a verbal warning. Then you want to move on to documenting it. So, okay, after you gave them that verbal warning that, hey, you've been absent or late a couple of times here, this is not behavior that can be tolerated and you are subject to termination if this continues. They do it again, then you want to write it down and you want to be detailed. You want to say, listen, this person was late on September 23rd, 24th, and 25th by more than X minutes. We met with them, you know, we've tried to understand what may be going on, and then have the employee write, "Hey, this is why I was late." Even sometimes with the text messages. So a lot of times employers are communicating with their employees on text messages, and so somebody white text, "Hey, I'm going to be 20 minutes late." Then you say, "Okay, why are you going to be late? Can you tell us what's going on?" So that way, the employee can't try to wiggle out of it once we get into the unemployment claim process. We have a documentation in real time where they said, "Oh, I'm this late because there's traffic," or "I'm late because I stopped and got Starbucks." Whatever the case may be, um, we want to document that. And then the last thing we want to do is give a final warning that basically is in writing that says, "You've been late X time." So again, we're going to lay out each time and the reason for each time. And then essentially you need to say, "This is your final warning. If you are late or you're absent, without, prior approval or without, providing a response, then I'm sorry, a justification, then you're going to be terminated." And then you have to actually follow through on that. So we can't be giving warnings without following through. Things that you definitely want to try to get is, if someone says, "Hey, I was sick," then say, "Okay, I understand. Can you just provide the medical note from, your doctor stating that you were sick or, you had a doctor's appointment on those days?" We want to just kind of document the reason because let's say the person is absent because they do have a medical reason, then the court is likely to find that that person didn't intentionally violate your rules or violate, just the standards of that can be expected of an employee. They had some justification. They actually had something medically going on. And then the last thing we want to do is we want to show the impact, or we want to have evidence of the impact of the employees' absences on the business. So things that we want to be able to show is, so for instance, if you're in retail, if the person's job is to open the doors and they have this pattern of coming in, 20, 25 minutes late, your doors are not opening on time. So that means you've got customers waiting, you've got loss of sales. So you want to try to do what you can to document that the doors did not open. If it's a situation where, let's say it's you have like subcontracts, and so your employee just doesn't show up. So the contractor that you have says, "Your employee didn't show up for their security shift, so I'm not paying you those 8 hours for their absence," or they're kind of basically cutting you short because they're not showing up on time. You want to document what that is. And then to the extent you have any customer complaints, "Hey, this person, was 30 minutes late, so therefore they made me miss my appointment, or my appointment ran over and now I was late for something else." So they give a complaint to your business because of the employee's behavior. Questions? Okay. All right. Case study 2, it would be something like intoxication or theft. These are behaviors that are very shocking, and I know employers want to just jump straight to, "Oh, that's a no-no," and just like cut the person off. But in order to be successful in an unemployment claim related to this type of behavior, you really want to slow down a little bit and at least do some investigation. Okay, so again, we always start with your employee manual. We want to make clear that the employee knew that drugs or alcohol, possession of that, and or being under the influence of that at work is grounds for termination. And we want to apply the rules consistently. So you can't say it's okay for my buddy John to come to work drunk, and then this person that I don't really the employee that I don't really like or know, it's not okay for them. You have to be consistent, and you have to be able to say to the court, "These are examples of where I consistently applied this rule." You want to investigate the allegations. So don't just jump to conclusions. So oftentimes, so I've seen it like in a construction situation where the employer is the subcontractor, they have employees on site. The general contractor calls up and says, "Hey, your employee John seems to be drunk at work. He's got to go." Um, don't just accept that person's statement without any type of investigation. First, to the extent that you have people from your office that can go to the site and actually see what's going on, that's great. You want to first give the employee a chance to respond and or refute the allegation. So, You want to talk to that employee, you want to talk to them in text. So you want to talk to them verbally, but at least you want to follow up with the text or an email that says, "Hey, John, on X date, such and such from the contractor said that you were slurring your words, etc. And there's a concern that maybe you're intoxicated. We want to give you a chance to address that. So can you tell us your view of what's happening? And also, we want you to go get a drug test so that we can address this issue." Okay. So you want to give that employee a chance to address the allegations. And then lastly, if someone is making allegations of, some behavior such as intoxication, theft, anything like that, you want to interview the person that's making that allegation and get them to give a written statement. Because one of the tricky things for unemployment is you've got to have witnesses to present at the appeal before the judge. And oftentimes, because the witnesses are people that are not either no longer employed by the employer, or like I said, they were like a contractor and the employer is the subcontractor, they don't have really control over those witnesses to compel them to come to court. But at least if you're documented, it's part of your witness file, and we can get over the hearsay rule because it's a business record. So you want to try to document what the various witnesses said about the person. And then if you got any other evidence, such as like photos, video evidence, you obviously want to make sure you capture and save that. Because I know, especially with like videos, those things tend to, I think people like rewrite over those over a certain time. So try to take a moment to like gather what is your evidence related to this particular thing. Behavior. All right. Case study 3. I'll call this the unmotivated or the lazy employee. You're just like, this employee just isn't doing the work. I'll tell you now, this one is a hard one to block from unemployment. So you got to really, really document what's going on. And don't do it at the first instance. You want to show a clear pattern that this person is consistently and intentionally not doing their assigned tasks. So, first, you got to have clear examples of whatever work it is that you've been giving that person. Because one of the things the employees often say is, "Hey, I did my work and I just was there because I've already completed it." So you want to show that you had tasks for that person to do and they didn't do it. And you've got to kind of document that. So I know there's a lot of different software that employers are starting to use so we can track, like, this was your task for the day. And then if you complete these tasks, here are your extra tasks. Or have a standard rule that, checks in with people, throughout the day to say, "Hey, what are you working on? If you completed those tasks, then here's some, additional things you can do." Again, like I said, there's tracking software out there now, that can really show you how long the employee has been online, especially for those of us that now have remote workers. It'll show you essentially what they're working on, and they should have to kind of do a daily or a weekly, however way you decide to time it, report of what it was that they did during that particular time period. So this is a way to kind of keep the employee aware that they need to report as to what they're doing. So obviously, if they don't fill in that report and you can show that they didn't do the work, then you kind of got them admitting it. And then any type of evidence where the person's going to be caught in the act. So if you got, this how often happens with security guards, they'll be sleeping at work, and it might be just because they're tired. But in any event, you can't. Everybody knows you can't be sleeping at work. So take pictures and do it on more than one occasion. So the court's going to say, "Look, we're not going to understand you want to terminate the person, but we're not going to block them from this government benefit just because one time they fell asleep at work." Okay, so you want to show a pattern of the behavior. And lastly, again, text is our friend because a lot of us will get informal, both employers and employees. As the employer, try to not be too informal with your text, but have text conversations with the employee where they might admit, "Hey, I just didn't do that. I didn't do that work, and I don't want to. I find it boring," or whatever the case may be. So, conversation could just go like, "Hey, John, notice that, you had XYZ reports due this week. We haven't received them. What's going on?" Um, and just, you'll be surprised at actually what the employee might admit in the present moment, and then you've locked them into those statements so that when we get to the unemployment claim with DOES and especially the appeal, they can't say, "Well, no, 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 this is what happened." It's like, "Well, no, but back here you actually said this was what was going on." All right. So tips to get ready for the DOES process and the appeal. So once you terminate someone, you pretty much should expect that they're going to apply for unemployment unless you've done some severance thing and you've already worked out the arrangement with them about unemployment or not. So keep your eye on it. DOES often will email whoever is listed as the contact for the unemployment account. So whoever that is needs to really be on top of checking spam, mail, etc., because there's a limited window for you to respond to DOES. So what happens is the employee files a claim, and then DOES sends a message, usually through Sides. It's a portal. If you haven't signed up for that, please take some time to sign up for that, to say, hey, the employee said that they were terminated, without justification. What's your reason for doing it? Remember, you're trying to speak to the statute for unemployment. So terminating you, all of us generally have at will employment. So we can terminate the person for any reason, good reason or no reason, right? That's not what we're trying to prove. We're trying to prove for unemployment that this person engaged in one of the statutory factors for misconduct that disqualifies them. So if you're just like, I just don't like that person, don't even bother. Just let that person get that unemployment claim. But if you got one of these specific, uh, behaviors, you want to then show all your documentation you can, and you want to get it in on time, because if you don't get it in on time, the DOES office is going to go ahead and issue that determination that the employee does in fact should receive unemployment. So you've got a limited window to do that. And then same thing, once you know a claim has been filed, you need to be constantly searching for, asking for, looking for that determination letter, because you have a very limited window of time to appeal. Like I said, it's just a few days. So you want to make sure that you're checking that, especially now that a lot of us are working from home. The mail might come and then it's just kind of missed. So if you got a claim in, you gotta be on top of checking the mail. Okay, a couple of other things, and excuse that typo there, but you gotta have a clear reason for termination. So sometimes what happens is the employer is like, well, this person had a bunch of issues going on. Okay, well, unemployment is going to require that you prove each and every reason that you say the person was terminated. So you got to be careful with your termination letter to not throw in the kitchen sink. Focus on one, two max reasons that you can prove with documentation and witnesses that actually are disqualifying reasons for unemployment, if that is one of your considerations when letting this person go. Also, you need to have witnesses with personal knowledge. Okay. So one of the things that, like, a lot of times the CEO is like, well, I'm just gonna send the HR person to do the appeals hearing. Well, unless the HR person actually made the decision, that's not going to help you, because the court is going to be like, well, the HR person don't really know. We need to have the decision maker testify as to what the grounds were and what evidence they had to terminate that person. Also, like I said, sometimes we have witnesses that are either no longer working with the employer, or were already outside of the employer. So that's why we want to have those witness statements, because and get those at the time that the incident is happening, because again, we could try to get those in as business records. And then, biggie, please contact me immediately upon after you get the determination letter, because this is all going to go so quickly. And I have such a limited window to get to know your business, how things work, what happened. And so the more time I have, the more effective I can be in helping you gather the evidence and preparing a more effective case. So with that, um, for those that are looking for help with navigating an unemployment appeal, please reach out to me at eap@dcchamber.org. You can also find more of these webinars through joining the DC Chamber, as well as going to the DC Chamber website, as we will be posting recordings of these sessions, as well as information about upcoming trainings. So if anyone has any questions, I'm happy to answer them. Questions for me? No? Okay. Well, I think that is it for me today. I thank you very much for joining and listening in, and I'm happy to, address any questions in case people want to discuss that outside of this webinar. Thank you. Don, back to you.
Oh, it only worked if I say all right, and I'm not on mute. Um,
Ah,
so no, thank you everyone for attending today. Please, I hope you were able to take away a lot of information. I mean, I learned something. As someone who actually used to have those type of conversations,
mm-hmm.
like I always, it's good to hear because I always thought like, oh, this red tape. So no, that was actually pretty cool. So thank you for
Good.
that. And yeah, I look forward work. How can we access the video later? I believe Lucky you go through and with the posting, correct?
Yes.
Yeah, so it'll be posted on our site, and you'll be able to see it on the DC Chamber site. But feel free to connect with us if you are unable to see it, and we can assist with that once the recording obviously posts. But all right,
Awesome. Lucky, I'm also going to send you a link to the regulations so that people can see the types of conduct that constitute misconduct.
Sounds good.
All right, great. Thank you all. Have a great day.
have a good day, everyone.
Bye-bye.